Hi, my name's Hugh Reed. I'm the CEO and founder of Reed Bar Review that offers both bar review training and bar review courses, also tutoring for the bar exam. Today I want to talk to you about parole evidence. And the word is, or the terminology is sort of misleading because it's not a rule of evidence, it's actually a rule of contracts. And the spelling of parole is very important. It's spelled without the E on the end. So parole, P-A-R-O-L. That's it, all right? So the general rule is that a contract can be based on either words or conduct. And for parole evidence, without getting too technical, I want to give you the short version. We have a writing, we have a contract. And the parties fully integrated or fully intended to integrate all terms prior to or contemporaneous into this final writing. In the real world, it's called a merger clause. It's generally the last or next to last clause in a contract saying, hey, everything we talked about or written about prior to this or contemporaneous with this writing is now incorporated into this final doctrine. That's what it is. Has nothing to do with subsequent agreements, everything to do with prior to or contemporaneous agreements. And the short version is that any evidence, extrinsic evidence or parole evidence later cannot be used to interpret this final writing as long as it's been fully integrated. Now, there are some exceptions, as you can imagine. And I remember the exceptions with damn foil, D-A-M-F-O-I-L. So on an exam, you would say, well, you know, parole evidence rule says, it's a contract rule that says if we have a writing where the terms of a contract have been fully integrated into this final writing, all prior to or contemporaneous agreements are not allowed by parole evidence or extrinsic evidence. However, subsequent agreements are not covered by the parole evidence rule. However, some of the exceptions are damn foil, D-A-M-F-O-I-L. So let's talk about those. The D in damn stands for duress. And it's got to be, it's got to be like gun to the head duress. Sign the writing or I'll blow your brains out, all right? That's duress. Not tested very often, I might say. So duress is not a big area. However, the second one, ambiguity. That's the famous ship peerless rule, remember? Where both parties believed they were contracting with regard to ship Peerless. However, there were two ships. And there were two ships named Peerless. So in that case, there was an ambiguity. Two ships Peerless, and each party subjectively intended a different Peerless. The M in damn foil stands for mistake. Mistake. It could be a mutual mistake, which is a lot easier to introduce extrinsic evidence, or it could be a unilateral mistake, where both parties are mutually mistaken with regard to the subject matter of the contract. It's easy to introduce extrinsic evidence to clear up that mistake, all right? Clear up that mistake. So, unilateral mistake is a little bit harder because the non-mistaken party has to be shown that he knew or should have known that the other party was mistaken. But mistake is one of the areas where parole evidence or extrinsic evidence can be allowed. The F stands for fraud. Fraud. Well, if one of the party is defrauding the other, we should allow extrinsic evidence to show that there was fraud, all right? So fraud is easy to allow extrinsic evidence to be allowed. The O stands for oral condition precedent. Oral condition precedent. where the legal effect of this contract is there was a condition precedent. So for example, I go to the car dealer and I execute a contract to buy an automobile for my son who's graduating from college, and I want to buy him a car. Well, he's not graduating several months from now. The next day after we execute the contract, the dealer is in court saying, hey, I want my money, I want my money, and extrinsic evidence is going to be allowed to demonstrate that the intent of the parties was that the contract was not to take effect until my son graduated from college, all right? And it's simply extrinsic evidence other than what we have in the contract. The I stands for illegality. Illegality. Well, if the contract is illegal when we execute the contract, it should be fairly easy to allow extrinsic evidence to demonstrate that the contract was for an illegal purpose, so that therefore the contract's void. However, if the subject matter of the contract is now illegal, then it should be, extrinsic evidence should be allowed to show that the contract cannot be performed. So, illegality should be an easy way to introduce extrinsic evidence. And finally, the L stands for lack of consideration, lack of capacity. If you recall, all contracts require COLL, C-O-A-L-L, C-O-A-L-L. Consideration, offer, acceptance, legal subject matter, and legal capacity of the parties. So that's all contracts require that. And then all of our discussions for contract should start with, is this a contract under common law, such as a service contract, or is it a contract under the Uniform Commercial Code? Remember, under the common law, we require essential terms. I remember the essential terms with Q-tips, Q-tips, quantity, time for performance, I, identity of the parties, P, price, price, and finally S, the subject matter, Q-tips. Whereas under the Uniform Commercial Code, we only require a quantity term, unless it's an output or requirements contract where only good faith is required. In other words, we don't need the quantity term for output and requirements contracts. And again, under the UCC, if there is some kind of ambiguity or some kind of interpretation, courts will require three things according to the code, and you can remember these. The first is course of performance. That is, how have the parties dealt with each other in the past in this particular contract. The second one is course of dealings. How have the parties dealt with each other in the past? And finally, course of trade or trade usage. What does the trade do in this particular instance? So that's how courts interpret contracts under the UCC, often tested. All right? Course of performance, course of dealings, course of trade. All right, where are we? Extrinsic evidence generally not allowed for a contract that's fully integrated, for prior to or contemporaneous agreements fully integrated into a final writing. We have some exceptions: dam foil, duress, ambiguity, mistake, F, fraud, O, oral condition precedent, I, illegality, and finally L, lack of consideration, lack of capacity. Lack of consideration, interpreted by the restatement, is did each party change their position to their detriment to execute this particular contract? Each party gave up something, all right? And lack of capacity, obviously, if a 15-year-old executes a contract with Best Buy to buy the huge stereo equipment that he or she needs for their room, well, that contract is voidable as to the 15-year-old. It's not voidable as to Best Buy, unless, of course, there are some exceptions like necessities. If that big stereo is a necessity for the 15-year-old, then an argument can be made that extrinsic evidence should be allowed to introduce, introduced by Best Buy, to introduce that the stereo was a necessity. All right, so let's do a summary. Look for a fully integrated contract, all right? Complete expression of agreements. Look for a writing. Look for an earlier agreement or contemporaneous agreement within the scope of the contract. Those are generally not allowed. Subsequent agreements are allowed, right? And then the exceptions are dam foil, duress, ambiguity, mistake, fraud, oral condition precedent, illegality, lack of consideration, lack of capacity of the parties. And that's how easy parole evidence, the parole evidence rule is, often tested, at least one if not two exceptions on the bar exam. For law school exams, I would urge you to look at your notes to see what particular subtopic of the parole evidence rule that your professor is enamored with, and fill in your class notes accordingly. You can always go to our website and you can download for free an outline, a lecture, the flashcards, everything you need for contracts to get a more complete discussion of the parole evidence rule. Thank you. Or you can call us, by the way, at 800-852-EXAM. Thank you very much.